If you've recently been selected as the personal representative or just filed a petition for probate, you're probably wondering who gets what. I'm Dan Wheeler, certified probate real estate specialist and CEO of All Things Probate DC, your one-stop shop for all your probate real estate needs. I help executors, families, and personal representatives navigate the probate process smoothly, efficiently, and with care. Whether you need help understanding timelines, marketing the property, or maximizing its value, All Things Probate DC is here to provide you with the expertise and support you need to make this journey less stressful and to get you the best possible outcome. The distribution of the assets is one of the most important and sometimes tricky parts of the probate process. Today, I'm breaking it all down step by step so that you know exactly how it works to avoid costly mistakes. First, estate distribution is not random. It's set on a strict order of priority set by DC law. Here's how the money flows. Court and administrative costs. Things like publications and bond premiums, funeral expenses up to $1,500, fiduciary and attorney's fees. This can be as high as $1 million. Homestead and family allowances, exempt property allowance, medical bills and care costs from the decedent's final illness, overdue rents and final judgments filed in the DC courts, and everything else kind of comes last. But here's the catch. If the estate doesn't have enough to cover all the claims, you may need to pay certain creditors pro rata, or equally based on the funds available. And for those lower on the list, unfortunately, they might not get paid at all. Let's make this clear. As the personal representative of the estate, you have a legal duty to pay all creditors in the correct order. If you don't, you could be personally responsible. For example, paying a lower priority creditor before settling a higher priority claim. That's a big no-no. When in doubt, always consult a licensed probate attorney. Once all the debts are settled, it's time to distribute the remaining assets. Here's what you need to know. If there's a will, the assets go to the people named in it. If there's no will, intestacy laws kick in and the assets go to the closest living relative, like a spouse or children. For minors or incapacitated heirs, distributions go to a court-appointed guardian or conservator. Before making any final distributions, you must prepare a final account. Interested parties have 60 days to review and object. This step ensures transparency and keeps everybody on the same page. Oh, and don't forget about the real estate. Whether it's sold or transferred, every deed must be recorded with the recorder of deeds to officially close the estate. This step is crucial to make the transfer legal and final. Managing an estate is no small task, but understanding how distributions work can make the process smoother and stress-free. But did you know that you can actually be challenged as the personal representative? Being appointed as the personal representative is not always smooth sailing. Sometimes you may face challenges from interested persons like beneficiaries or heirs who may have some issues with how the estate is being run. If you're interested in watching that video, click right here because it's coming up right now.